Zoom and welcome everybody here. As you just heard, we are recording this. So for those of us who are enjoying our lunches here in person, I guess if you want to opt out of recording, we can set you up on Zoom somewhere else, or I hope that's okay, but this way people can view this in the future. And for those of you who haven't met me, I'm Gail. I'm the president of the Connecticut Valley LERA. So this is our first in-person Zoom hybrid meeting in a long time. Some of us haven't seen each other in years in person. And so please bear with us as we try to adjust to this new technology and this new normal. And we'll do the best we can with sound and video and audio and all of that stuff. I want to give a big shout out to Robinson and Cole. I know Natalie just left the room for a moment, but him and his team here at Robinson and Cole for hosting us and letting us use their IT equipment here. And of course, many thanks to our folks in Illinois, Bernadette from our national LERA, who they keep the trains going in the right direction and supporting us on Zoom, and it's very much appreciated. We are planning in our next program for December 9th. It will be on Zoom exclusively, and we hope it will be done on that day. It's possible it will get postponed where we need to find a few more speakers, but really just kind of having a debrief with management and labor about virtual arbitrations and what worked, what hasn't worked. And so anyone here or on Zoom, if you're willing to participate, let me know. And finally, we are looking for some folks to serve on our steering committee. Our steering committee is 15 people, and we try to have that representation equally among folks who represent management, folks who represent employees and unions, and then our arbitrators and other neutrals. So again, we're looking for someone who represents management, someone who represents employees or labor. And if you're interested, please send me a note. That would be great. So our usual housekeeping details, as we've already said, we're recording this. And so if you want to see the recording in the future, you do need to be a member of LERA. And you can renew your membership online through our website. And everyone here, obviously we can hear each other. Folks on Zoom, I believe you're muted. Natalie is going to monitor the chat room so we can take questions that way. CLE email, certificates will be emailed after the show and after the show. After the presentation. And for those of you on Zoom, just make sure you have a name and not a phone number, because I won't be able to identify you. And I'm going to turn it over to our presenter, Mike Cass, who is the officer in charge of the Hartford office of the National Labor Relations Board. Very grateful to Mike for stepping in here. He too has had to juggle a few things in the way this presentation is going to be offered today, but very grateful. Thank you, Mike, and I'll turn it over to you.
Okay, thank you. So as mentioned, I'm officer in charge of Subregion 30 for the National Labor Relations Board office in Hartford. The Hartford office is a subregion of Region 1 Boston, and Region 1 Boston, our overall region, is led by Regional Director Laura Sachs. Originally, Regional Attorney Thomas Quigley was going to join in the presentation today, but unfortunately he will be unable to attend. So I'll do my best to handle both portions of what we'll plan to discuss. And broadly speaking, I'm going to be talking about representation procedures that we follow, past and present, and some relatively recent board decisions. As many of you know, the National Labor Relations Board is an independent federal agency that regulates private sector labor relations for employers and unions. Members of the public, employer representatives, and union representatives file representation petitions when they seek an NLRB run secret ballot election to determine whether or not a union will represent a group of employees. And the same folks may file unfair labor practice charges when they allege a violation of the National Labor Relations Act. So in other words, we don't go out and investigate or set up elections on our own. We act based upon what's filed with us from the public. Most representation cases are filed, as you might imagine, by unions seeking to represent a group of bargaining unit employees. And these are called RC petitions. Individual employees who seek an election to remove an incumbent union file what's called an RD petition. And in the event an employer believes there is a question concerning representation of their employees, they may file a so-called RM petition. Now, for most of the first 30 years of my career, I've been here that long and considerably longer, NLRB election case procedures remained largely unchanged. However, beginning in 2014, the board issued an election rule seeking to streamline the processing of representation cases. And a change of administrations led to a substantial amendment to the 2014 rule in 2019. And following some litigation, portions of the 2019 rule were enjoined. As you might imagine, the pace of these changes over the last few years, which has been so dramatic compared to the first 30 years of my career, has led to some confusion about what procedures are enforced today. And I'm hopeful that this presentation will help resolve at least some of those questions. And at least for now, as it is possible, as almost always with the NLRB, there may be further changes in the future, but a little more on that later. RC and RD petitions constitute the vast majority of our cases. So in talking about representation cases, I will focus primarily on them. When a party or an individual files a representation petition, it must be supported by what we call a showing of interest, which is 30% or more of the employees in the planned for bargaining unit must express their support for being represented for purposes of collective bargaining by a labor organization. Similarly, if an employee files a petition seeking to remove an incumbent union, that petition also must be supported by a 30% or more showing of interest. This showing of interest generally consists of what we call union authorization cards or signature petitions that state that the signer wants a certain union to represent them, or in an RD petition that the signer no longer wants to be represented by the incumbent union. Assuming the showing of interest is adequate, that is 30% or more of the employees at issue, the board agent assigned to the case will attempt to negotiate an election agreement that will provide for a secret ballot election to be conducted by the NLRB. The vast majority of our representation cases result in election agreements. However, if there is an issue that prevents the parties from reaching agreement, the field office conducts a hearing where all parties have the opportunity to present witnesses, documentary evidence, and arguments to support their contentions. Prior to the new rule and the amendment, the hearing date also had to be negotiated between the parties, and that sometimes resulted in substantial delays in processing. Also, any issue that a party raised prior to 2014 could be used to require the running of a hearing. For example, a party could refuse to enter into an election unless, say, for example, their contention that 3 persons out of a bargaining unit of 200 was supervisory was resolved through a hearing. In that case, we would have no choice but to run a hearing on the status of these 3 individuals, even though the chances that the votes of these 3 persons would have a substantial impact on the votes in a unit of 200 it seems odds on would be unlikely. Following a hearing on an issue like that, the regional director would review the record and issue a decision, and in most cases, a direction of election, where the director decides what the appropriate bargaining unit should be, and then directs that a hearing be held. That decision could be appealed to the NLRB in Washington. So prior to 2014, the election rule that issued then, this was essentially the process. And about the only thing that did change over the years was the time goal that field offices should strive to achieve in conducting elections. For example, the very first election agreement I negotiated as a rookie field examiner provided for an election 56 days following the date that the petition was filed. As a newly minted board agent, I was feeling pretty good about this accomplishment until a day later when the file reappeared on my desk. It had on it a buck slip from then officer in charge, Peter Hoffman. All that was on the slip was a very large black letter B, followed by a large black letter S. I'll leave it to you folks to read between the lines. I then learned that the goal at the time was to schedule elections for 55 days or less prior to after the petition was filed. As you might imagine, I was soundly chastened by this development, and I immediately sought out my supervisor and carefully recorded any and all time goals that the agency had at the time. So really the only thing that changed in the next 30 years was various administrations and general councils and boards sought to speed up the process. And that usually came down to telling the field offices that the time goal they were to strive for running elections was decreasing. So it eventually went from 55 down to 45. And the last time we had a time goal, specific time goal set in stone, it was 42 days. And then 2014 came with significant changes. The majority of the board members in 2014 were appointed by President Obama. After a long process of soliciting input from the public, the election rule was released. There were substantial changes, including that a notice of hearing would issue the same day that the petition was docketed, setting a hearing date for 8 days following the filing of the petition. There were limits on how much delay could be, or extensions of time could be granted, and typically only a day or two would be permitted in terms of rescheduling the hearing date. Employers were also required to present 3 days prior to the hearing a statement of position of what has been characterized as the SOP, no later than noon 3 days prior to the hearing. It was also to be a mandatory pre-hearing conference the day before the hearing. That was the stick behind all of this, I guess you'd say, is the failure to timely file the statement of position would result in the employer being quote unquote precluded from raising any issues or presenting any evidence or argument at a hearing. And with a few exceptions, any issue not raised in the statement of position could not be added in later. While there were no expressed election scheduling goals, regions were directed to schedule elections, quote unquote, as soon as practicable. The 2019 amendments. In 2019, a majority of the board members had been appointed by President Trump, and they issued what was termed the Election Protection Rule that amended the 2014 rule. Included among the changes was that hearings would now be scheduled on docketing of the petition for 14 days following the filing of the petition rather than 8. Also, parties could not be, quote unquote, precluded from raising issues that, if unresolved, would require a hearing. So it was back on the table that any party that wanted to delay the process or maybe had a legitimate concern about something, they could raise any number of issues that they felt that should be litigated before it was determined what the appropriate bargaining unit was and when and where an election would be conducted. The employer requirement for a statement of position was retained, but it was now 8 days following the petition filing, and it added something called a responsive statement of position, what we now term the RSOP. And that meant that the petitioning union or any other party to the case, sometimes we have more than one union, for example, or in an RD petition, we have the employee petitioner, him or herself. They are now required to provide by noon 3 days before the hearing, the field office and all the other parties with their position on the issues raised in the employer's statement of position. I think you can see that the purpose of all of this, whether it was the Obama board or the Trump board, they wanted both parties to flesh all the potential issues out in advance of the hearing. In the past, when I first began, it could happen that you'd start a hearing and one or more of the parties would be in the dark as to what was going to be litigated until the day of the hearing. So that in the view of both boards, created a situation where it was more likely that we would have a hearing and litigation rather than the parties taking the time to sort out their issues and get an election agreement. The amendment did retain the mandatory pre-hearing conference, which continues today. And the 2014 rule that required that employers provide a voter list or list of eligible voters 2 days following either approval of an election agreement or a decision and direction of election. The 2019 amendment lengthened the voter list due date to 5 days rather than 2. Rather than scheduling elections as soon as practicable, the 2019 amendment forbids scheduling an election any sooner than 20 days following the issuance of a decision and direction of election. So is this the gist of what the NLRB election rule provides now, you may ask? The answer is no. All this became further complicated because after the 2019 amendment was issued, the AFL-CIO went into federal court seeking to enjoin the 2019 amendment, arguing that it had been unlawfully implemented as it did not comport with the Administrative Procedures Act. Essentially, under the Administrative Procedures Act, what the then board majority argued to the court was that these were mere ministerial changes in election procedure. And the court didn't see that way on at least some aspects of it, and thought that they had to follow other procedures in the Administrative Procedures Act. So on May 30th, 2020, then District Judge Tanya Brown Jackson, now Supreme Court Justice Jackson, issued an order enjoining 5 provisions of the 2019 amendment that she deemed unlawfully implemented. The injunction made the following changes. First, it reinstated the regional director's discretion to defer ruling on issues where an election could otherwise be held. So going back to that example of 3 people in dispute about a 200-person unit, these days a regional director will typically say there's no reason for me to decide that. If it remains an issue post-election, it can be raised post-election in a proceeding at that time. It also reinstated that the schedule of elections should be as soon as practicable, as opposed to the 20-day lead period that the 2019 rule had envisioned. It reinstated the requirement that the voting list be provided by the employer within 2 business days following approval of an election agreement or issuance of a DMDE rather than 5 days. It also rescinded I think a minor requirement, but that election observers must be employed in the voting unit whenever possible. What that means is, functionally, is that any party can have an observer who is a non-supervisory employee, but not actually a voter, not included in the voting. It also reinstated the regional director's authority to issue election certifications, notwithstanding the filing of what's called a request for review, or essentially an appeal of what the director's finding has been. So where are we now? In some, hearings are scheduled 14 days following the filing of a petition. Employers in RC petitions must file a statement of position by noon on the 8th day, specifying any issues it deems a hearing will be needed for, and provide employee lists for those in the petition for unit and separate lists of employees that the employer contends either should be added or excluded. This filing must be served on all parties and must be timely served on all parties. And that means by noon on the 8th day. There are no exceptions. There have been cases that have occurred where someone filed one minute late and it's been determined you're out of luck. There have also been other cases where they've timely filed their statement of position with us, but whoever they had tasked with serving the other parties went to the bathroom or got a cup of coffee and waited until 12:02 to serve the other parties. And similarly, you are then precluded from raising anything that you put in your statement of position. So I like to tell everybody, file everything at 11:30 a.m. Things happen. We know that, for example, that our e-filing system sometimes has some issues. Well, I think you want to build into the process your ability to, fax it to everybody or email it to everybody, but just get it in on time. There's no, and if you're precluded, sometimes the thing that gets precluded by that operation is something that it may be that all parties have an interest in trying to resolve pre-election. So it's just good to lay your cards on the table and lay them on the table in a timely fashion.
Can I just bring up one point? I got a question in the chat, not really a question. We are unable to make the mic specific to microphone specific to mic. So the microphone is picking up sound in the room. Just this, someone asked if we could move the mic closer, the microphone closer to mic. We're unable to do that, but I guess we'll try and keep the room noise to a minimum.
Do I need to speak louder? I guess that's one.
I don't know if that'll work.
Okay. All right.
Just need 2 more soft. I finished my potato chips, so I'm not worried.
Next time we only order quiet food.
Yeah, next time no potato chips. Okay.
And Mike, while we're stopping, are you willing to entertain questions during your presentation? Okay, good.
Sure.
Okay, great.
So
Okay.
yeah, just I don't know. So as to the material you've covered right now, I have a couple of questions.
Sure.
One of them, which is, you said there's a process for testing the adequacy of a showing of interest, right? What I don't see that very frequently, but what does that look like? What kind of issues?
Well,
can arise
sometimes
in
an
that-
employer
in
will
that?
say, we want to provide you with a payroll list so that you can check whatever union cards you have received against the payroll list, because we want to make sure these people that sign cards are in fact our employees. And that's conducted administratively. What that means is there is never an instance where an employer or a union gets to litigate the validity of a showing of interest. It's something that we do independently, but if a party has a doubt about whether or not the showing of interest is valid, by all means, they send us a letter with stating their concerns. And if they have some, to use a bizarre example, yeah, I saw this guy sign 6 cards by himself and put them in an envelope. I've never had something like that.
Right.
I did have this is many years ago, but I did have a situation where a union filed a petition. It was during the period of time when we had a lot of grocery stores merging left and right in Connecticut. And one union that thought they were being enterprising signed up a bunch of people who were standing in line for hiring interviews for one of these taking over merger, a new employer going into the same place. And the union filed a petition based on that, which we ended up dismissing because basically these people weren't employees yet. No one knew. It was enterprising, but unsuccessful.
So that's an issue brought forward, but an administrative investigation that's done independent of the parties at
Correct.
that point. And so those are, I would imagine, I know you've never had it, but in cases where there's some kind of fraud or something like that, whether it be a RC or an RD,
But
that can take some time, right?
If it looks like the cards have all the same handwriting,
Yeah.
or a signature page has all the same handwriting, we may talk to the person who presented them to us. And we won't divulge that to all the parties, but would be an obvious question.
Understood.
So we would look into that.
We've got one comment here that it wouldn't hurt if you could speak a little more loudly. But
All right, I'll try.
Okay. The other question is, I know that there was I read that there was a lot of criticism about resolving some of the supervisory issues post-election, because you could end up with a situation in which supervisors were actually, voting or participating as non-supervisors in the discussions, right, with prospective unit employees about, the vote. Have you seen those kinds of issues?
Well, we hear about them.
Right.
Typically what we'll hear about is an employer may say, I want these people that are in dispute to be my ambassadors in conducting my campaign. So, and all we can say to them is, well, we can't tell you what to do, but if you have the way we do things is we're trying to get the ballots in the box. So we don't think it's worth everyone's time and effort and the taxpayer's dollar to run a hearing, and with the delay that inevitably engenders, we would rather go ahead and run the election. If say in the example, there's 3 people that the employer thinks are supervisors and the union thinks are not, so then the employer observer is probably going to challenge them as being supervisors, or vice versa. And that's how we would get into it in a post-election proceeding.
That was my follow-up question.
yeah,
Through a
so-
challenge, not a UC.
But well, it would be if the challenges were determinate. In other words, if there were enough challenges that it could tip the election one way or the other. If not, we're going to go ahead and certify the results if the union lost, or certify the representative if the union won. And then it's up to the parties to decide if a union is certified. Typically, they try to bargain out that in connection with collective bargaining. Well, what do we do with these 3 people that were at issue? If that doesn't work out, then either party may file, as you mentioned, what's called a UC or a unit clarification petition. And in that instance, the first thing we do is one of my agents would collect in writing the positions of the parties. Well, why do you think these people are in? Why do these people are out, et cetera? And we'd see if, we could tell from the paperwork and from the arguments of the parties, if we might say, well, it kind of looks like they're in, or kind of looks like they're out. But if there are factual things that we just can't resolve, well, then we're going to run a hearing, and one of our agents will be a hearing officer. And then, similar to issuing a decision in direction of election, the regional director would issue an order clarifying the bargaining. So say, for example, there were 3 people challenged as supervisors, and those positions were deemed to be non-supervisory. The director would issue a unit clarification, which would be an order that said, okay, here's the original bargaining unit. We're adding these 3 classifications, or these 3 people in this classification, to the existing bargaining unit, and go forward from there.
Thank you.
Sure. Oh, okay. So I think I've completed most of that part, except following the injunction, the NLRB implemented the 2019 rule minus the 5 items that had been enjoined by now Justice Jackson. However, the NLRB appealed the injunction to the DC Circuit, where it's been sitting for more than a year. And the AFL-CIO also went to the DC Circuit, advancing their claim that the entire 2019 rule was improperly implemented pursuant to the Administrative Procedures Act, and that it should be completely vacated and we should return to the 2014 rule. We don't know why this is taking so long. I am aware that there was a side argument made by the NLRB, and to the effect that Justice Jackson, or then Judge Jackson, the district court, should not have been involved in this, that it should have been filed initially at the circuit court level. I'm not sure of the exact rationale for that. I can guess. And the reason is NLRB board orders, once they issue, if they are to be appealed to a court, or if they're going to be enforced by the NLRB, we go to circuit court. We don't start at the district. So that may be the nature of their argument. And that may be something that's kind of holding things up, because it's kind of an unusual situation. But we don't know. And I checked just this week with the Office of Representation Appeals if they knew anything new about this. And the gentleman I spoke to said, well, Mike, the DC Circuit issues its decisions on Tuesdays and Fridays. So they didn't, I talked to him on Wednesday. They didn't issue anything on Tuesday, but it is at least possible that you'll be talking to people on Friday and something will happen, and everything you won't know about it till afterwards. So we'll see. Okay. And then finally, no one knows if the Biden board members, who now constitute a majority of the board, if they will seek to engage in any sort of rulemaking related to this whole issue. They have said they proposed that they are interested in rulemaking relating to something called the board's blocking charge policy. And I'll just say very briefly about that. In the past, if someone, a party to an election, filed an unfair labor practice charge, that it could be argued that if violations were found under that charge, it would invalidate any election that you were about to run. And so the board historically had said, well, we don't want to go out and conduct an election if it turns out that it's just going to be invalidated. Why would we spend taxpayers' money doing that? We're just going to not do that. And then there would be circumstances where there would be last-minute appeals of a blocking issue to the board, and the board might say, well, we don't want you to block the election, conduct the election, but impound the ballots until such time as you determine whether the unfair labor practices alleged would affect things. That was changed with the 2019 rule, where they basically said, in every instance, you're not going to block. You're going to conduct the election, and you're either going to count them or you're going to impound them, kind of at the discretion of the director and depending upon the type of allegation involved in the unfair labor practice charge. That has led to some unanticipated situations. For example, where we have actually a case going on now where there's an allegation of an unlawful recognition of a union and what we call an 882 violation. And based upon that, an election petition was filed by what had been an incumbent union, who was replaced by the allegedly improperly recognized union. In the past, what we would do with that sort of situation is, if we determined that the 882 allegation, the employer dominated or assisted union allegation, had merit, we would not conduct an election. We would hold the election petition in abeyance while the litigation went on of the 882, which sort of made sense. But now, based on what the rule says, it's clear that situation was not anticipated. So we don't know what's going to happen with that case. But so that some of these things, NLRB stuff and our case stuff, gets very complicated very fast.
On the representation side, as the regional director, the ultimate authority before going to the board?
Yes.
Yeah, right. So you don't have the general counsel to go through in those situations on representation cases.
No, because the board essentially controls the general office of the general counsel. While they employ us in the field offices, they can't, the office of general counsel doesn't insert herself into representation case issues, which is why they have a separate office of representation appeals with the board, and why, if you have an issue that you really have to get before the board where you disagree with the director, you file a so-called request for review.
On that scenario that you just outlined, the case that's pending, which I have nothing to do with, not my case. If I understood what you say you've made a decision, you found merit to the charge.
Yes, there was merit found to the charge.
I mean, what's the case, Reese Riley, whatever the case that came down within the last few months, seems to say you clearly still have the authority to dismiss the petition.
What's up in the air is what we do with the petition.
Okay,
It hasn't been decided. So I don't know what anyone's going to decide.
No, I'm not asking you but you do have. But the petition is filed by the union that unlawfully got ousted in your potential findings.
Correct.
Okay.
But it's my
it doesn't seem like they would want to have them. They may not want to have an election in that situation, but I'm not.
Well, it's a really complicated
Yeah.
situation. And my point in mentioning that case was that sometimes with the rule changes, as intelligent and skilled as the people are with the board that put these things in place, they don't always anticipate every single situation, and you can end up with a place where it's like the classic fitting the square peg in the round hole. How do we, for the people in the field, it's like, well, what the heck do we do with this thing? So that can happen, but we'll see. All right. Okay to proceed?
I don't have any questions here now.
Okay. So one thing I just want to mention briefly before I go into some other things is just that how busy we are. Election petitions processed by the NLRB are up 53% between fiscal 2021 and 2022. And unfair labor practice charges have increased by 19% between the same two fiscal years. And this represents, you combine them, you get the field offices handling 23% more cases. So we're doing the best we can, but our staff has been eroding over the years. You've probably seen the press that we've been level funded for 9 years. And if anyone in business or working for anyone else, you know that your costs to rent space or to pay your people don't go down, they go up. So it makes it, we have to do more with less.
Mike, may I ask,
Yeah.
are you seeing any particular themes in those unfair labor practice charges that are being filed?
I guess actually before we went on, I was mentioning to Natalie that one area that we are seeing a lot more of is individually filed, also filed by unions, but individually filed charges with people who claim that their employer has unlawfully restricted them from discussing their terms and conditions of employment. So the classic thing is we have a rule against you folks talking about what does Joe make versus what Mary makes. You can't be talking, sharing information like that. That's a violation of the law, has been since the cows came home, I guess. And I often wondered, did that come out of, like, for some people of my age, when I was younger, my parents would get very upset with me if the kids on the block were sharing what they thought their parents made. They thought that was also confidential. And I wondered if that's sort of bled into when people became adults, their feelings about how things should be handled at work. I don't know. But in any case, it's become a garden variety violation. And some employers, in addition to restricting people or even having handbook rules that say you can't discuss your terms and conditions with other employees, if they find that you've done that, they're, in some cases, they're disciplining, or in rarer cases, discharging someone for that. And those are going to be, generally speaking, meritorious cases. So we'll see how that all works out in time, but that's a common issue these days. Right. One other thing about our cases that I wanted to mention before going on to unfair labor practice cases, and that is one of the big issues in our cases because of the pandemic has been the question of whether we run a manual ballot election, which is when a board agent goes to the employer's facility and sets up a booth and voting box and brings in an observer for each side and conducts the election and counts it right then and there, or do we do it by a mail ballot? Certainly at the height of the pandemic, we were running pretty much exclusively mail ballots, especially pre-vaccine and that sort of thing. In fact, I ran the first manual election that our office had in, I think it was September of 2020, which, thinking back to then, you folks may remember it was horrible in the spring and early summer of 2020. And then it seemed to be August and September, and positivity rates were nosediving. And the board was saying, had issued a case, which is called, it's hard to pronounce, Asperus Kiwana. And it's a acute care hospital in Minnesota. And the board in that case came up with half a dozen metrics, I guess you'd say, or standards for when a mail ballot should be called for in light of the COVID-19 pandemic. And those consisted of, one, if the agency office tasked with conducting the election is operating under mandatory telework, which is what we were doing for a lot of the last few years. Two, either the 14-day trend in number of new confirmed cases of COVID in the county where the facility located is increasing, or the 14-day testing positivity rate in the county where the facility is located is 5% or higher. 3, the proposed manual election site cannot be reasonably established in a way that avoids violating state or local health orders relating to maximum gathering size. 4, the employer fails or refuses to commit to abide by General Counsel Memo 2010. And that was a memo issued by former General Counsel Peter Robb that set out a number of requirements for the employers had to put in place to have an on-site manual election. And these were things like a facility that was large enough so that social distancing could be maintained, that everyone in the room would be wearing a mask, that there had to be a separate entrance and exit for the voters, that there had to be plexiglass screens surrounding the board agent and the observers, and basically isolating everyone from each other for that election. And the 5th one, there is a current COVID-19 outbreak at the facility, or the employer refuses to disclose and certify its current status. Or 6, the catch-all, other similarly compelling circumstances. And that number 5, part of General Counsel Robb's memo was that 48 hours before we conduct a manual election, the employer is required to provide a certification as to how many people, if any, have got the bug, are quarantining, but because of the bug, are waiting test results because of the bug. And, for obvious reasons with this pandemic. And one of the things that it seems the parties don't always appreciate is they might say, well, yeah, we had, 5 people got sick and they're quarantining. Well, if they're quarantining, they're not going to be able to come in to vote, and people seem to somehow forget that. But that's an issue. And we put in our election agreements now that a couple things. One is all of the requirements of General Counsel Robb's safety requirements, they're part of our election agreements. So with 48 hours before, if you file a certification and say, yeah, we got 10 people got the bug, we're going to convert it to a mail ballot election. And similarly, if any of the other factors of asperus were met, we're going to convert it to a mail ballot election. The thing that changed with this Starbucks case is, and I'm not sure if this is of interest to folks, it is to me, it became very difficult to rely upon the positivity rate, which is one of the asperus factors, the 5%. And the reason for that is, and I'm sure you've seen it on the news, people started getting the home tests and you couldn't know what the real positivity rate was because you didn't know if people were testing negative, testing positive, you just had no way of doing that. So what the board in this Starbucks case did, it's NLR 371 NLRB number 154, issued just at the end of this September 29. They said the asperus standards stay in effect, but we're modifying the second one. And the CDC has now come up with this ranking by county of transmission, where they get a variety of informations and they meld it together and they rank it as the transmission level being either low, medium, or high. And so now that category 2 that used to talk about 5% positivity rate now just says if the county where the facility is at a high level of transmission, a regional director can direct a mail ballot and not be said to have abused their discretion. So that's really the main change.
To your earlier point about the division between the board and the general counsel, how did the general counsel come to issue a memorandum regarding representation proceedings?
Well, he's still the boss of the people in the field, and he had to, and the general counsel still supervises like the mechanics of the election, I guess you would say. So, but that was one of the issues because it was like, well, until the board acts, what do we do? And any general counsel from either party placed in that position, I think, if you started ordering people to conduct manual elections and they turned into a super spreader effect, incidents, how long would you have your job?
Right, understood.
So it was just, so that's what was done. And as a practical matter, for a long time, we did almost exclusively mail ballot elections. So, the first one we did in 2020 was one I did personally, based on the fact that I was not going to order somebody to do something that I wouldn't do myself. And it went smoothly and nobody, including me, got sick. But you could, that was a time when before the vaccinations were out. So it was, but it was at a time when transmission levels, for whatever reason, were low. And I myself argued at a time when I was an acting regional director to the board itself at a conference later on, after the Delta surge hit, that Asperus was all well and good, but the Delta was different. That was a game changer because it was so much more transmissible. And I don't think anyone, but I can't fault them. I don't think anyone had an answer to what to do at that point. So, all righty.
Mike, I just want to keep track of time. I know we
Yep.
started a little late because we were lunching, but we were about 1 o'clock. So maybe we can go for a little while longer and then take some more questions as well.
Sure. Okay.
Great.
All right. Well, I will try to be a little briefer on the next part. So I just wanted to mention a couple of, oddly enough, everyone I think anticipated that when the Biden board became a majority, there would be wholesale changes in some of the cases that the Trump board decided. That may yet happen, but at the moment there's not a lot of case law, but there are a couple things that have changed. So in a case involving a guy that's been in the news today and his company, Tesla, on Twitter, the board in this Tesla case, the employer had restricted people at a Tesla plant from wearing T-shirts that had union graphics on them. And the board in this particular case, 370 NLRB number 131, decided to reverse a case that it held that in Walmart that it held that an employer could demonstrate a reason why they could restrict people from wearing T-shirts and the like. And the board went back to a case called Republic Aviation, which is an ancient case, Supreme Court case from 1945, no less, which affirmed that employees have a protected right to display union insignia under Section 7 of the Act. Now, the board members were split on this. The Republican members, the Trump appointee members dissented. They didn't disagree with the notion that insignia can be worn, but they just thought, well, they could wear a little sticker or a little button, but I don't think they can wear a whole T-shirt because the employer has an interest in building team membership, so that they can require employees to wear a Tesla team member shirt, sort of thing. So that's something that has changed. And then another case that came down relatively recently is Valley Hospital Medical Center. And basically this case came back to the board on remand. And this involves survival of a union security clause following expiration of a contract. And this is another issue that has gone back and forth. In 1962, in a case called Bethlehem Steel, the board held that an employer was free to end dues checkoff in its contract upon expiration of the contract. The Ninth Circuit later criticized the board for failing to explain its approach in that case. And a long time later, in Lincoln Lutheran in 2015, the board held that dues checkoff is to be subject to the general statutory rule requiring employees to maintain most terms and conditions of employment after contract expiration to facilitate bargaining for a new agreement. In other words, when a contract expires, the general rule of thumb is an employer can't change the terms and conditions in that, even though the contract is expired, absent agreement with the union or bargaining to a good faith impasse where they can then implement. And then in Valley Hospital 1 in 2019, the board majority at that time reversed the the 2015 Lincoln Lutheran case that had reinstated the idea that dues checkoff survived the expiration of the contract. And then I think it was the Ninth Circuit sent it back saying, you really haven't adequately explained this. And so in Valley Hospital 2 issued September 30th, 2022 at 371 NLRB number 160, the board said, we're going back to Lincoln Lutheran of Racine, and they overruled Bethlehem Steel, the 1962 case. So that's the current law of the land on that. And other than that, and the Starbucks thing on Aspris, there have not really been, to my mind at least, some really significant changes in board law that happened yet. However, the General Counsel Abruzzo has issued a number of General Counsel memos, all of which are available on the agency's website. And she's seeking to change a variety of things. So back in September of 2021, she issued a memo, let's see, number of it, 22-06. Oh, no, I'm sorry, that's the updated memo. The original one was 21-07, and then there's another one, 22-06. Again, they're all available on the website. And she's seeking additional, what she calls full relief through settlement agreements. So as she says, a settlement agreement fully effectuates the mission of the National Labor Relations Act when the agency can deliver timely, effective, and full relief to discriminatees in the public we serve. Regions should skillfully craft settlement agreements that ensure the most full and effective relief is provided to those whose rights have been violated. And if a settlement fails to materialize, regions should seek all appropriate remedies from the board. And then she goes on to note that regions are to seek compensation for any and all damages, direct and consequential, attributable to the unfair labor practice at issue. It provides some examples related to compensating discharged employees, such as costs associated with that, health insurance coverage, medical, legal, or moving expenses, detrimental effects to credit ratings, liquidating a bank account to cover living expenses, training or coursework required to obtain or renew a security clearance, certification, or license. So basically what we've been instructed is, and similarly, we've been instructed to seek no less than 100% back pay benefits owed for all matters due, plus any consequential damages, as well as front pay if an employee decides to voluntarily waive reinstatement. And in cases where an employee's unfair labor practice has caused the loss of an employee's work authorization, regions are advised to seek a settlement agreement requiring the employer to sponsor work authorization of the affected employees. That would be somebody working in this country on a visa. And that memo also had us reinstate the so-called default language for settlement agreements, which basically says if the employer or the union that is settling the case fails to comply with the settlement agreement, the only argument that they can make to avoid a default judgment is that they have in fact complied with the settlement agreement. Otherwise, they don't get to litigate the basis of the case. Now that's the General Counsel's direction. They have also issued a notice seeking briefs, and I guess this is just still ongoing, in a case called Thrive Incorporated, THRYV, 371 NLRB number 37. And they have asked interested parties to file briefs stating that asking should the board modify its traditional make whole remedy in all pending and future cases to include relief for consequential damages, where these damages are a direct and foreseeable result of a respondent's unfair labor practice. Alternatively, should the make whole remedy include relief for consequential damages only upon findings of egregious violations by the respondent? If consequential damages are to be included in make whole relief, how should they be proved, and what would be required to demonstrate that they are a direct and foreseeable result of an employer's unfair labor practice?
So that's a recent decision?
No, they haven't. it's basically, it's a pending case. The board has said that they had solicited parties to basically file amicus briefs,
Okay, so the
saying
citation,
what they think.
right, so the citation. was
So,
to the-
so the citation is to their order saying, tell us what you think about this stuff. What considerations support making the proposed change to the board's traditional make-whole remedies? What considerations support retaining the board's traditional exclusion of consequential damages for its make-whole remedies? So what's going on here is the general counsel has said, regional offices, you're getting settlements. So in the context of settlements, you can seek these things. But the board has not formally said, yeah, you should make these a part of, getting a remedy for a board order. It would require the board to go along with these, some or all of these suggestions by the general counsel of what she wants in settlements to then be part of the compliance process for board orders.
So how do the regions handle that?
We do what the general counsel tells us in terms of settlement agreements, but she's also said, if you can't settle the case and you have to litigate it, you should argue in favor of getting these additional consequential damages in connection with the litigation. So, and personally, I've had only one ancient experience with something that would arguably be a consequential damage. And it was kind of a heart-tugging situation. We had a discriminatee in a case who'd been unlawfully discharged for being involved in the union organizing campaign. There was no question it was a slam dunk win. I think the employer essentially conceded that. They knew that they had someone on the ground that had violated the law in their either supervision or management. But while that case was pending, one of the discriminatees had a massive heart attack and passed away. And he had he not been unlawfully discharged, a $10,000 life insurance policy. And so what ensued was an argument over, well, that was a term and condition of employment. I mean, it was, he got the free to him $10,000 life insurance policy. We think you should pay up. And the employer resisted that for a while. And I'm not sure if they convinced their insurance carrier to just pay up or what, but eventually his widow did get the $10,000. So I mention that only because that would be the type of scenario, but broader than that, that if the general counsel's initiative is, particularly if it's adopted by the board, it would be in the case of board orders too, that if you have something like some woman's car got repossessed because she was unlawfully discharged and lost work, or someone got behind on their mortgage payments, or a harder thing to remedy, I guess, I haven't figured that out how we do that yet, is someone's credit rating takes a hit because they got late on their bills because they unlawfully lost their job. All of these things, just by the way, also apply to unions. So if a union, discriminated against someone, say in a construction site, like a case I had years ago where a guy was laid off for lack of work, who was African-American, and suddenly the Italian nephew of the local president had the same job. And we turned that around, but the same would apply to a union in that situation that was responsible for that type of discrimination, that they would have to make someone whole for not just lost wages and obvious benefits, but if there were so-called consequential damage. Yes, sir.
How do, for all these elements of damages, what is the NLRB's position on interest? Interest from the day of something happening to the day of an order?
Well, on back pay, we typically charge whatever the IRS charges. So that varies by quarter. I think that's up to 6% now. Something when I was a compliance officer, I paid closer example to that. For a long time, that really hasn't meant much, because when the interest rates were so low and we were settling a case, it's, well, you get 1% interest, and it's just not that big a deal. Back when I was a compliance officer and interest rates were double digits and it would compound with every quarter, and then they changed it so that it's compounds daily, the interest payments can get to be quite substantial, especially in a higher interest rate atmosphere.
I saw some headlines on the consequential damages issue for a case, I think it was out of the, whatever region covers Atlanta and the
Region
mine.
10, yeah.
Yeah, that was, I don't know how long ago it was, but I think it was in the last year where consequential damages were being applied against the union. I don't know if you have any insight on that. There was some really astronomical figure that made the headlines, but I haven't followed to see what's happened since.
I haven't. I don't. Sorry to say I don't know. It's ringing a bell. It's way back there somewhere. Sure. My partner in crime suggests I take questions if there are any.
I want to be respectful of the time. Do you have a few more?
I can ask
updates?
questions.
Go ahead, Tom.
Well, so has the GC memo on settlement rate, settlement terms had an impact on the settlement rate in the region, at least as far as you can see? Or nationally, if you got.
Well, the main thing I think, that comes up faster than consequential damages is the 100% versus we'll take 80% of back pay. And most employers and unions are just paying the 100%. They haven't been fighting that. We haven't had, to my knowledge, a case where there's been, and it doesn't mean that there hasn't been, but it's slipping my mind, where there's been a true consequential damage, where someone was said, my credit rating went down, or my car was repossessed, or I lost my house. I mean, all of those things under what the general counsel is talking about would be something we would be seeking.
You don't have any insight into whether there is into whether there's likely to be a budgetary increase when and if Congress passes another budget.
No, I don't. I mean, we've been level funded for 9 years. And one of the really hardships for us is wages go up and rent goes up and utilities go up. But if it's the same budget and we've lost a lot of people to retirement, and the hiring process is it's sort of like, for me, it's akin to really harsh torture. It's months and months of harsh torture, and it's unfortunate, but that's the way it is.
I mean, well, there was a substantial increase proposed in the 2021 budget, and in the final budget negotiations, it disappeared.
I mean, I don't know why. No one ever told us why. I assumed that it was something that conservative members of Congress said we don't want to do. That's all I can presume, but I don't know. And at some point, there is, in all budget deals, I mean, at some point it's like, well, we don't want to shut the government down. So, and we're not a huge, I don't know if we're, I've become used to my career, to our agency becoming kind of a political football, unfortunately. But we just wake up every day, go to work and do our job.
I've put in the chat to see if anyone has any questions. I'm not seeing any, but.
Okay, well, I'll just mention a couple other things really quick that are kind of interesting. First, for sports fans, the general counsel has said that she thinks that under the broad language of section 2(3) of the act, so-called student athletes can be considered employees of universities, and that they would have the rights. Private universities, athletics at private universities, those people would have rights under the National Labor Relations Act. Probably, and I probably should have said this one earlier, and I'm sorry about that, but I think everyone's familiar with it. The general counsel has issued a memo finding that captive audience and other mandatory meetings by employers are unlawful. So there's a part of the act called 8C, which is entitled the Employer Freedom of Speech section. And based upon that, the board had said previously that employers could require employees to attend meetings where anti-union discussions and literature and films and all that stuff was provided. And General Counsel Abruzzo is arguing that you can have those meetings, but you cannot require them, because she thinks that that's violative of Section 8A1 of the Act, and that is inherently coercive to require someone to do that. And she points out that people can't be required to attend a union meeting or a union organizing meeting. So for fair play, it should be, similar thing should be in effect. Frankly, I sometimes wonder if all of this stuff is a lot of hullabaloo about nothing, because I'm thinking about employees I've dealt with working in a plant or somewhere, and if the boss says, come on over here, we want to talk to you about something, we're going to give you some coffee. No, I'm going to stay at my drill press. I mean, I just think that's kind of unlikely to happen. But at the moment, if captive audience meetings, we are to litigate them. But having said that, like, that's what I mean, and the board can say, it's voluntary, you can come and hear what we have to say, our side of the fence.
Do you have any of those? I know there's a case pending before the board on that issue, correct?
We have had a couple where we got settlement agreements, where the employer said, okay, yeah, we shouldn't have run that meeting, we're not going to do that again. But, sometimes that's because, well, I don't know why. It's because, I shouldn't say that. I'm not sure why they elected to do that. Maybe the cost of litigation. I mean, it's a line in a notice typically. So if you're running a business and somebody like you says to your client, well, we can litigate this and it's going to cost you X. Or if you go along with this line in the notice, it's going to cost you Y. I think that's what happens. So, and then just this, I guess this will be like the final thing I'll say. And on this issue of rulemaking, I mean, this was prior to the 2014 election rule. I think the biggest one was the healthcare rule that was in the mid 80s, where Marshall Babson, who I had many cases with, he was with Wigan and Dana, eventually became a board member. But when he was a board member, he helped to shepherd through the healthcare rule changes. And basically what that did is, it used to be in hospitals, you would have very splintered bargaining units, and unions would try to organize one little department or another little department. And the board said, well, look, we're going to come up with these presumptively appropriate units, and they divided them up. And that sort of made, because otherwise we'd run these hearings that would go on for weeks about trying to figure out whether the respiratory therapist should be in the same unit as the physical therapist or something like that, But so in June of this year, the current board issued what they called their spring rulemaking agenda. And one that I think everyone has heard about is the joint employer status under the National Labor Relations Act. But the second one says procedures governing charges, voluntary recognition, and the formation of Section 9A bargaining relationships in the construction industry. That's really all I know. What form that takes at some point, I presume they're working on it, but I don't know.
Are there any other questions in the chat, Ms. Owen?
I'm not seeing anything in the chat, no. I appreciate you taking all those questions.
Well, and if there are further questions, I encourage people, you can call me, you can call my information officer of the day. They're all very skilled and they know a lot about what we do. Thank you for the opportunity to talk about what we do day to day.
Thank you.
Thank you very much.
Thank you very much.
Attending and putting up with our crunching and munching, and check the website and you'll be getting a note either from myself or Zach about hopefully our December 9th meeting. So thank you very much, and enjoy the rest of your day and your weekend.
Thank you.
Thanks, Bernadette.
Thank you,
Take
Bernadette.
care.
Where is the mic?
It's somewhere in the ceiling. I think it's over there. And so it somehow.
So it's still pick up people eating potatoes.